We're going to get started. If people could take their seats. Welcome to the opening plenary of the 119th annual meeting of the American Society of International Law. We are very excited to welcome you this evening to Washington, D.C., to join the community of international lawyers who have traveled from around the globe for 4 days of amazing programming. Fantastic speakers, timely discussions, and perhaps most importantly, the chance to connect with each other again. If you're new to the Society, I encourage you to become a member and take advantage of the Society's rich program of events, publications, and research. I especially want to welcome this evening's distinguished guests, Professor Tendaye Achiume, our 2025 Grotius Lecturer, Jawil Dakwar, our distinguished discussant, and Dean Heather Hughes of the American University Washington College of Law. The opening plenary, thank you, yes. The opening plenary of the Society's annual meeting for 27 years now is the Grotius Lecture. This lecture was named after Hugo Grotius, the 17th century legal philosopher who was a central figure in the development of international law. The lecture has become a mainstay in our community for addressing important issues of international law and policy. The Grotius Lecture has covered topics as varied as a third world view on the promise of international law, harmony and dissonance in international law, just war and humanitarian intervention, and restoring democracy through international law, to name just a few. ASIL is proud of its long partnership with American University Washington College of Law for these past 27 years and the important contribution of this series to the field of international law. I especially want to note the contribution of our dear friend, Professor Padide Alaei, who is the director. Padide is the director of Washington College of Law's International and Comparative Legal Studies program. She has been a longtime supporter of the mission and work of the Society and contributes greatly to putting on tonight's lecture. At this point, let me introduce Dean Heather Hughes, who will share some welcome remarks and will introduce our two keynote speakers. In addition to serving as interim dean of Washington College of Law, Dean Hughes teaches commercial, business, and property law. Her current research concerns the impact of emergent technologies on law and the legal profession. Before joining Washington College of Law in 2007, Professor Hughes practiced in the business department at Morrison & Foerster and was an assistant professor as part of the founding faculty of FIU College of Law. Professor Hughes won in 2019 the WCL Award for Excellence in Teaching. In 2017, she won the Edmund A. Moores Scholar Award, and in 2010, the Emily C. Godsey Scholar Award. I am pleased to welcome Dean Hughes to the podium.
Thank you, President Hodgson, for that lovely introduction. On behalf of American University Washington College of Law, good evening and welcome to the 27th Annual Grotius Lecture. 27 years ago, American University Washington College of Law's then director of the International Legal Studies program, Professor Daniel Bradlow, proposed a public lecture at the opening of ASIL's annual meeting with the explicit purpose of bringing new voices to this, the oldest learned society of international law. Tonight, I'm honored we are carrying this storied tradition forward with our fantastic lecturer and discussant. They're going to speak about this year's important and timely theme, traditions and transitions in international law. Before I introduce this evening's distinguished guests, I want to thank those responsible for this fantastic evening, including the American Society of International Law, President Melita Hodgson, Executive Director Michael Cooper, Justine Stefanelli, the ACEL staff, and of course, Professor Patti Deolai and all of my wonderful colleagues who work in our International and Comparative Legal Studies program at American University, Washington College of Law. Thanks to all of you for coordinating this event. It's now my pleasure to introduce tonight's speaker, Tendai Achiume, and the discussant, Jamil Dakwar. Tendai Achiume is a professor of law at Stanford Law School. She is an extraordinary professor in the Department of Jurisprudence at the University of Pretoria, a research associate with the African Center for Migration and Society at the University of Witwatersrand, and a research associate at the Refugee Studies Center at the University of Oxford. Her academic research explores the global governance of racism and xenophobia and the legal and ethical implications of colonialism and other forms of empire for the governance of international borders migration. In recognition of the exceptional creativity and promise for important future advance of Achiume's research in these areas, she was awarded a 2023 MacArthur Fellowship. Professor Achiume is a former United Nations Special Rapporteur on contemporary forms of racism, racial discrimination, xenophobia, and related intolerance, and was the first woman to serve in this role since its creation in 1993. For the 2024-2025 academic year, she's a scholar in residence at the Institute for Advanced Study in Princeton. Thank you for being here, Tendai. I'm also so pleased to introduce Jamil Dakwar, our discussant. He's an international human rights lawyer and adjunct professor at New York University and Hunter College. Currently, he leads the American Civil Liberties Union's Human Rights Program, which conducts research, litigation, and advocacy to hold the U.S. government accountable for its international human rights obligations and commitments. His expertise frequently appears in domestic and international media, and he serves as the ACLU's main representative to the United Nations and leads the ACLU's international advocacy before other regional and international bodies, including the International Commission on Human Rights. Notably, in 2004, Mr. Dakwar was one of ACLU's first observers to the military commission system at Guantanamo Bay. In 2020, he was appointed as a member of the New York State Advisory Committee to the U.S. Commission on Civil Rights. Prior to joining the ACLU, Mr. Dakwar worked at Human Rights Watch, where he conducted research, advocated, and published reports on issues of torture and detention in Egypt, Morocco, Israel, and Palestine. Before coming to the United States, he was a senior attorney with Adalah, a leading human rights group in Israel, where he filed and argued human rights cases before Israeli courts and advocated before international forums. Mr. Dakwar serves on the board of several organizations, including the International Service for Human Rights, the Foundation for Middle East Peace, and the Adalah Justice Project. Thank you for being here, Jamil Dakwar. At this point, please come to the stage and join our illustrious speaker. I am looking forward to this lecture. Thank you.
When President Trump took office on January 20th, 2025, he issued numerous executive orders. Among them, one that suspended the admission of refugees into the United States. This executive order includes carve-outs for refugees whose admission may be in the national interest of the United States. and notes that it is the policy of the United States, quote, to admit only those refugees who can fully and appropriately assimilate into the United States, end quote. A little over 2 weeks later, President Trump issued a second executive order entitled, quote, addressing the egregious actions of the Republic of South Africa. This order directed the Secretaries of State and Homeland Security to, quote, prioritize humanitarian relief, including admission and resettlement, through the United States Refugee Admissions Program for Afrikaners in South Africa who are victims of unjust racial discrimination, end quote. The government-sponsored race-based discrimination in question includes what the order describes as, quote, countless government policies designed to dismantle equal opportunity in employment, education, and business, including a recent law that, again, according to the order, enables the government of South Africa to seize ethnic minority Afrikaners' agricultural property without compensation. The executive order targeting South Africa also holds all other aid or assistance to the country from the United States because South Africa has, quote, taken an aggressive position towards the United States and its allies, including accusing Israel, not Hamas, of genocide in the International Court of Justice, end quote. Having largely closed the borders of the United States to refugees, the US presidency has created an exception to protect, quote, ethnic minority Afrikaners from purported state-sponsored racial persecution. What is the South African legal framework that the aforementioned executive order broadly refers to as government-sponsored race-based discrimination? Although the order does not elaborate, its references to countless government policies designed to dismantle equal opportunity in employment, education, and business can only be interpreted to refer to the constitutionally mandated affirmative action frameworks that the South African government has pursued to redress the institutionalized white supremacy of the prior apartheid and colonial governments. This framework includes the broad-based Black Economic Empowerment Act, whose fundamental objective is to advance economic transformation and enhance the economic participation of Black people in the South African economy. Afrikaners, the ethnic minority singled out by the Trump administrations, are the descendants of the Dutch, who settled in the Cape beginning in earnest in 1652. Over the course of the next 3 centuries, British and Afrikaner colonial domination forged the nation-state of South Africa as an explicitly white supremacist state that subjugated the peoples of this territory who were racialized as Africans. A legacy of this colonial foundation, which includes the formal regime of apartheid imposed by the Afrikaner National Party, remains a profoundly racially unjust social, political, and economic order. According to a land audit by the government of South Africa in 2017, more than 20 years after the formal end of apartheid, whites, who comprise about 8% of the population, owned 72% of the country's privately owned farms and agricultural holdings. Land reform is a hotly contested issue in South Africa, and the government is subject to criticism domestically across the spectrum of perspectives. Some argue it has gone nowhere near far enough truly to undo colonial land ownership, and others, including right-wing Afrikaner groups, argue that it has gone too far. But I want to focus on President Trump's framing of the Expropriation Act as unjust racial discrimination, a framing that demands an understanding of race and racism that completely suspends the historical and contemporary context of South Africa's colonial and apartheid foundations. With this and other cases in mind, my lecture today considers the meaning of race and racism that dominates in international law and international relations. It considers the colonial context that has structured that meaning and the project of redress that has received resurgent attention under the paradigm of reparations. Thank you very much to the American Society of International Law and the International Legal Studies Program at American University Washington College of Law, President Hodgson, and especially Professor Padide Alai for the invitation to deliver the Grotius lecture. I can hardly believe it, if you can imagine. It's a real honor. Thank you also, Dean Hughes, for the generous introduction, and to my distinguished discussant, Jamil Dakwa. In preparation for this lecture, my reading included the final report of the ACIL ad hoc committee investigating possible exclusions or discouragement of minority membership or participation by the society during its first 6 decades. As I address you today, I'm mindful of all of the work that many have done and continue to do to hold our society to the ideals that it professes, not least of all Professor Henry Richardson, who chaired the ad hoc committee. I dedicate this lecture to my grandmother, whose life trajectory defies the regimes of subordination that obtained at her birth on a native reserve in colonial southern Rhodesia. In 1608, about 40 years before the Dutch began settling the Cape of Good Hope, the first Europeans arrived in the native territories currently occupied by Washington, D.C. Washington, D.C. would go on to be the center of the domestic trade in enslaved Africans in the 19th century, operating one of the most active slave depots in the nation. Slavery was abolished here in 1862, but the injustices it underwrote remain with us to the present. The land on which we are present today is the ancestral land of the Natoktank Indians, who neighbored the Piscataway and Pamunkey peoples. This was a vibrant trading territory, rich in raw materials and abundant in crops. The Natoktank are said to have extended a warm welcome to early European settlers, but contact with Europeans would ultimately pose an existential threat to them, fundamentally altering the course of their history and decimating their lifeways. According to the officials at the National Museum of the American Indian, there is no living Natoktank lineage left. The indigenous peoples who do still reside in this area continue to fight for, among other things, restoration and full recognition of their sovereignty. My aim for this lecture is to reflect on the project of global racial justice and what it entails. At this time, when colonial racial domination remains entrenched and the global system faces profound reconfiguration, my remarks are in some sense an attempt to argue the urgency of a fight that has at its center a commitment to planetary interconnection on egalitarian terms. This, I think, is a counter to the unabashed weaponization of racial justice, which is being used to entrench racial domination. International law prohibits racial discrimination. As jus cogens, the prohibition enjoys the status of being hierarchically superior to other rules of international law and being universally applicable. In addition, across the international legal frameworks enshrining human rights, discrimination on the basis of race, color, ethnicity, and related grounds is prohibited across treaty regimes, with the International Convention for the Elimination of Racial Discrimination offering the most comprehensive regime. One might expect, then, that the international law prohibiting racial discrimination would have had an important role to play in undoing the racially unjust structures that European colonialism entrenched here in the United States, in South Africa, and everywhere else where this entrenchment is manifest. One might expect that the prohibition on racial discrimination has been central to providing reparations for colonial injustice. Yet, when this prohibition has been applied to the context of land reform in South Africa, specifically Zimbabwe, by regional and international adjudicators, it has been applied to prevent rather than facilitate redress for colonial racial injustice. In 1980, when Zimbabwe gained independence from British colonial settler rule, 6,000 white commercial farmers owned 42% of the country, secured through legal frameworks that on a racial basis dispossessed the black majority of all but the most arid and fertile land. By 2000, Zimbabwe's agrarian economy was still dominated by white-owned farms. As part of a broader, violent attempt to remain in power, then President Robert Mugabe oversaw a constitutional amendment for land reform. The land reform program adopted authorized the uncompensated compulsory seizure of agricultural lands for redistribution and formed part of a broader attempt by the Mugabe regime violently to remain in power. Mike Campbell, a white Zimbabwean commercial farmer who had purchased his farm prior to independence, initiated a class action lawsuit that challenged the government's forced uncompensated acquisition of farms. Central to this lawsuit, which was ultimately adjudicated before the Southern African Development Community, the SADC Tribunal, at the time the Apex Regional Tribunal, was the litigants' claim that although the land reform program did not de jure target farms on the basis of race, in effect, it targeted only the land of white farmers in Zimbabwe. On this basis, its disparate impact on white farmers the litigants argued the land reform program constituted unlawful discrimination under international human rights law. Vindicating this claim, the tribunal found that the government had violated the prohibition on racial discrimination because the land reform program had, quote, an unjustifiable and disproportionate impact on Zimbabwean white farmers only, end quote, in violation of the International Convention on the Elimination of Racial Discrimination. The decision of the SADC Tribunal was surprising for a number of reasons, not least because the text of the International Convention for the Elimination of Racial Discrimination explicitly permits race-conscious special measures or affirmative action. On the one hand, there were dimensions of the land reform program that were legitimately flawed and unlawful, including from a perspective that genuinely prioritizes egalitarian land redistribution and racial justice in the country. But as I've argued in more detail elsewhere, the tribunal's finding of racial discrimination seemed not to rest on these flaws, and instead on the fact of this unjustifiable and disproportionate impact on Zimbabwean white farmers only, end quote. In this regard, the Campbell decision is a stunning example of what Christopher Gevers has termed the depoliticization and the dehistoricization of race in a context where the contemporary salience of colonial injustice and the racial nature of that injustice were vividly manifest. Nowhere in the tribunal's reasoning, and mind you, this is a Southern African tribunal, does it consider the fact that prior to independence, and indeed when the farm owned by the lead plaintiff in the suit was purchased, whiteness was the formal basis for title in the vast majority of Zimbabwe. The court is also dismissive of the fact that at the time of the adoption of the land reform program, vast tracts of land were held almost exclusively by white farmers in Zimbabwe. The tribunal's conceptualization of race and racial discrimination severed both from the historical and political colonial context that constructed their meaning, and as a result, produced doctrine in the name of non-discrimination that further entrenched the colonial racial meaning in the present. If whiteness in Rhodesia meant a legal entitlement to arable land, and blackness meant the negation of an entitlement, the tribunal's decision effectively reproduces this colonial structure into the present. Dina Tsavala's analysis of an international arbitral award concerning Zimbabwe's land reform program further illuminates the work that legal doctrine does to reproduce the colonial meaning of race, even while professing a commitment to curtailing racial discrimination. 7 years after the Campbell decision, an investment arbitration tribunal issued the Von Pezel decision, following claims brought by white foreign investors owning large commercial farms in Zimbabwe under bilateral investment treaties between Zimbabwe and Germany and Switzerland, respectively. This tribunal was the World Bank's International Center for Settlement of Investment Disputes, or an ICSID tribunal. The timber farms at issue in the Von Pezel case naturally have a colonial genealogy. They were initially planted by the British South Africa Company, which some of you may know settled Zimbabwe, or Rhodesia as it was at the time, in the early 20th century. And the timber farms were established following the forcible displacement of indigenous communities who were forced into native compounds in the course of the colonial settlement process. The Von Pezel Tribunal found that the land reform program in Zimbabwe, through the land reform program, Zimbabwe had failed to provide, quote, a legitimate reason for implementing an unjustified policy that discriminated against the landowners on the basis of their skin color and their foreign ancestral heritage, thereby contravening its obligations erga omnes not to engage in racial discrimination, end quote. The tribunal insisted that, quote, there was ample evidence that the claimants were targeted in the present case on the basis of their skin color, end quote. In her analysis of the award, Tsavala observes again the depoliticization and dehistoricization of race and racism in the tribunal's analysis, in which the tribunal constructs affirmed temporal separation between the past as the locus of racial discrimination and an egalitarian present that eschews the past altogether. Notably, she underscores the racial and temporal function of property rights in Zimbabwe, where private property rights were created to vest the economic interests of white settlers in land. In a 19 British Privy Council decision adjudicating whether the British Crown or the British South Africa Company held the title to large tracts of then Southern Rhodesia, the Council was unequivocal. Quote, "Some tribes are so low in the scale of social organization that their usages and conceptions of rights and duties are not to be reconciled with the institutions or the legal ideas of civilized society. Such a gulf cannot be bridged," end quote. The same doctrine that naturalized the theft of native land as property in the United States would perform a similar function in Southern Africa. This doctrine helps suture the worlds of colonizer and colonized and effectively remains good law. In its insulation of litigants' property title from attempts to undo their racial foundations, international law was mobilized by the tribunal, in effect, to maintain colonial racial injustice as a contemporary feature of Zimbabweans' relationship to their land. Along the remedies ordered by the ICSID tribunal was restitution of the litigants' commercial farmland. The von Pezzold family has since sought enforcement of the ICSID arbitration award in the United States, and in November 2024, the U.S. Court of Appeals for the District of Columbia ruled the award was enforceable in the United States, among other jurisdictions. The application of the prohibition on racial discrimination in the two cases I have described replicates a dynamic that critical scholars of international law have identified as a general feature of the dominant approaches to race and racism in international law. To a great extent, international law's dominant conceptualizations of race and racism tend to elide and obfuscate their colonial genealogy, the manner in which race and racism reproduce colonial injustice. Recent legal scholarship, especially within the traditions of third world approaches to international law and critical race theory, map a range of the deficiencies of international law and practice in this regard. Drawing on the work of scholars Laura Stoller and Deborah Thompson, international legal doctrine and even global governance more broadly exhibit what we might call colonial racial aphasia. In her critique of French historiography, Stoller describes colonial aphasia as a political disorder, characterized both by the occlusion of knowledge as a political form and the occlusion of knowing as a cognitive act. Aphasia is, quote, a dismembering, a difficulty speaking, a difficulty generating vocabulary that associates appropriate words and concepts with appropriate things where colonialism is concerned, end quote. Thompson builds on Stoller's conceptualization of aphasia in this sense to argue that the field of international relations exhibits a similar condition, racial aphasia, which entails, quote, a calculated forgetting, an obstruction of discourse, language, and speech regarding how the modern world system was founded on and continues as a hierarchical racial order. For Thompson, racial aphasia produces collective silences regarding racism as a global and pervasive social structure, and these silences themselves then contribute to link our racist past to the still racist present. Consider the following example. In 2020, the United Kingdom at the United Nations Human Rights Council voted in opposition to a resolution that annually aims to set the global agenda for concrete action against racism, racial discrimination, xenophobia, and related intolerance for United Nations member states. The UK issued a statement explaining its negative vote, and I highlight two features of this statement. The first is that the UK repudiated any obligation on the part of colonial and enslaving powers to make reparation for the slave trade and colonialism. A repudiation that framed colonialism, including the transatlantic trade in enslaved Africans, as a terrible but lawful set of events in the past that render reparations demands legally moot. Secondly, the UK presented demands for reparations as not only legally moot, but also as irresponsible distractions from, quote, the pressing challenges of tackling contemporary racism and global inequality, end quote. It established a wedge between the project of reparations and the project of the global governance of racism, indicting attempts to connect the two projects as normatively and strategically counterproductive. Although the UK statement was made on behalf of one country, it captures the general orientation of other colonial and former enslaving powers that form part of the Western Europe and Others group, WEOG, a consequential voting bloc and political influence within the United Nations. This general orientation minimizes the contemporary relevance of historic colonial racial injustice and is often put into practice through opposition to global governance reform that could truly change these persisting injustices. In place of the necessary shifts in the global economic and political order, we are given, for example, the Sustainable Development Goals and anti-reparative, predatory, muscular international regimes such as international investment law. On review of what international legal scholarship there is on reparations for colonialism, including the transatlantic trade in enslaved Africans, this scholarship has largely focused on the mandated remedial framework for internationally wrongful acts. It locates colonialism, including the transatlantic slave trade, as events in the past with the dominant conclusion that often being that there exists no international legal obligation to make reparation for colonialism and the transatlantic slave trade. An important body of work, including 2 symposia convened by Judge Robinson of the ICJ and co-sponsored by ASIL and the University of the West Indies, challenged the view that reparations are foreclosed under the Articles of State Responsibility for internationally wrongful acts. At the same time as different actors pursue reparations within this framework, we should be wary of an approach that conflates and reduces the normative and programmatic core of reparations for colonialism and the transatlantic slave trade to providing remedies for unlawful conduct in the past. Accountability for events in the past is critical, but so too is dismantling structures that reproduce historic injustice in the present. Reparations in international law and within the global system demand what scholars such as Sarah Riley Case and Olufemi Otaiwo and others have described as a world-making approach, concerned foremost with undoing colonial relations and structures of domination and patterns of distribution that still shape the global order. To a great extent, a preoccupation of my work as the United Nations Special Rapporteur on Racism sought to document this racial reproduction of historical injustice on a global scale. The contemporary meaning of blackness, for example, retains the colonially constructed presumption of danger, inferiority, otherness, and so on, that are manifest transnationally, say, in the frameworks that construct and govern criminality. So too, the contemporary meaning of whiteness retains the colonially constructed presumption of superiority and so on. This is not to say that the conditions that we're experiencing in the 21st century are identical to the conditions in the 20th or the 19th and so on. People racialized as black, for example, are legally entitled to own land in places such as Southern Africa, where prior to formal decolonization, land ownership was limited primarily to people racialized as white as a matter of law. This is an important and emancipatory shift in the legal meaning of blackness. But land ownership in the region remains profoundly inegalitarian on a racial basis, in significant part due to legal, economic, political, and social regimes that reproduce colonial relations and structures of domination, even though these regimes differ from those that obtained under formal colonial domination. The contemporary meaning and function of blackness or any other colonially originated racial stratification shifts over time, but retains its colonial core, keeping people and places fixed in their colonially stipulated hierarchy. I want to be clear that in my view, reparations are not only about what colonial and enslaving powers owe to the peoples they colonized and they enslaved. They are also about ensuring that China or Russia or India or South Africa or any other nation, state, or corporation, for that matter, cannot rely on the transnational racial hierarchy that, for example, defines the labor of formerly colonized peoples as endlessly exploitable. The goal is a global order where race and racism no longer operate as generative economic and political transnational resources. Insofar as race and racism are means of reproducing economic, political, social, and epistemic dominance by deploying scripts that associate morphology, ancestry, geography, and self-determination on terms defined through colonialisms, reparations require legal frameworks that disrupt race and racism. A crucial site for these ambitions is the global governance of race and racism. Reparations entail tackling contemporary racism, and global inequality, and conversely, the global governance of contemporary racism, is fundamental to the project of reparations. International law is a site of contestation. It always has been. Whereas my remarks so far have focused on colonial racial aphasia and dominant conceptions and applications internal to the field of international law, such conceptions have repeatedly been challenged, especially by mass mobilizations that have understood international law and sites such as the United States, the United Nations, as crucial but not exclusive sites for emancipatory struggle. In 2020, a movement that had gained momentum in the United States under the banner Black Lives Matter catalyzed a transnational mobilization against racism, with an emphasis on understanding contemporary racism as rooted in the legacies of the transatlantic trade in enslaved Africans and colonialism more broadly. In the wake of the uprisings, a letter by over 600 human rights groups led by the ACLU and the US Human Rights Network demanded that the UN Human Rights Council convene a special session to investigate the situation in the United States. Prominent voices within this coalition self-consciously situated their appeal within a broader historical trajectory. Jamil Dakwa, my distinguished discussant and director of the ACLU's Human Rights Program, for example, stated plainly that the appeal of human rights organizations to the UN in 2020 followed, quote, the legacy of great Black leaders such as W.E.B. Du Bois, Martin Luther King Jr., and Malcolm X, who believed in internationalizing the struggle for human rights and racial justice in the United States, end quote. As early as 1947, the NAACP's An Appeal to the World, drafted by Du Bois, was one of the first submissions by a non-governmental organization requesting human rights investigation of a UN member state. This and other early petitions laid the groundwork for the 1951 We Charge Genocide petition, which was submitted to the United Nations General Assembly by the Civil Rights Congress. While earlier petitions had requested investigation into racial domination on the basis of human rights principles, the Civil Rights Congress's petition directly invoked the newly enacted Genocide Convention to charge the United States with conspiracy to genocide, as demonstrated, quote, by the evidence of the suffering and deaths of 10,000 Blacks and the ways they were uniformly segregated, despoiled, impoverished, and denied equal protection as a result of deliberate, all-pervasive policy of the government and those who controlled it, end quote. 3/4 of a century later, South Africa is attempting to use that very convention to put an end to Israel's brutal, chilling military campaign and humanitarian blockade, which, in the words of the UN Secretary General, has turned Gaza into a killing field. In 2020, with respect to reparations in particular, at the time of the racial justice uprisings, I argued in my capacity as special rapporteur that demands central to the mobilization were effectively demands for reparations. At the heart of the mobilization was a critique of the global reproduction of the racial injustices of colonialism and the transatlantic slave trade, especially in the realms of policing and law enforcement. Many of the social movements that catalyzed and led the protests had long been at work producing granular knowledge on what reparations for colonial racial injustice can look like in varied contexts. It is not an overstatement to describe what happened in 2020 as a seismic shift in the global policy and popular discourse on racism as a transnational historical structure. Even if this shift was contested, even if it was constrained, and even if it also catalyzed tremendous backlash and subsequent retrenchment. The uprising shifted the conceptualization and discussion of race and racism within the UN system, both in terms of norm and institutional development, as well as in terms of the organizational structure of the UN system itself. The Office of the High Commissioner for Human Rights and the UN Human Rights Council are both sites where the 2020 racial justice uprisings shifted conceptions of racism more meaningfully to account for the persisting structures of colonial injustice. Examples include the Office of the High Commissioner's 4-point agenda towards transformative change for racial justice and equality, which includes, among other things, a set of urgent measures required to end systemic racism and the need for states to, quote, recognize that behind contemporary forms of racism, dehumanization, and exclusion lies the failure to acknowledge the responsibilities for enslavement, the transatlantic trade in enslaved Africans, and colonialism, and to comprehensively repair these harms, end quote. In 2024, the UN Secretary General publicly called for reparations for the transatlantic slave trade as a way to tackle its legacy in today's society, including systemic racism. In the report, he notes that, quote, reparatory justice is not just about redressing wrongful acts of the past. It's about building societies that are truly inclusive and free from racism and discrimination. A comprehensive approach should therefore be to address the past, the present, and the future. In my view, this framing of reparations was catalyzed by the 2020 uprisings. Now, highlighting these shifts may seem to miss the forest for the trees. The United Nations confronts an existential crisis, perhaps most concretely manifest in its acute liquidity crisis. What good are stronger anti-racism norms in a seemingly imploding multilateral order? Whether one is invested in defense of this multilateral order or ultimately the pursuit of a more just system of planetary interconnection, neither end can be achieved by simply dismissing the forms of racial injustice that characterize the current order. A global system that fails to reckon with the anti-racist demands of the transnational racial justice uprisings of 2020, or to reckon with the more recent transnational protests insisting on the equal worth of Palestinians, is demonstrably untenable. Equally untenable is a system that cannot counter the weaponization of anti-Semitism, of anti-Black racism, anti-Palestinian racism, or any other structure of subordination, especially where this weaponization can be so crucial to the dismantling of that very system. Attention to the real demands of social movements, not the caricatures of their demands, is instructive. As rising authoritarianism challenges the liberal democratic order, those who have always been subject to authoritarian relations that are characteristic of the borders of liberalism, I think have a lot to offer. And I want to be clear here that one can mark a definite inflection even while tracking patterns of continuity. And in my role as special rapporteur, I was struck at how you would visit a country and the lived conditions of people in that country would vary dramatically depending on their racialization. And so I will read that sentence again. As rising authoritarianism challenges the liberal democratic order, those who have always been subject to the authoritarian relations characteristic of liberalism's political and geographic borders have something to teach us. As we bear witness to the weaponization of equality and non-discrimination, the weaponization of the project of building societies that are more just and egalitarian, it is important as it has ever been to do the work required to ensure that self-determination does not function as a racial privilege. In conclusion, what should international lawyers do where reparative anti-colonial world-making to undo racial injustice is concerned? It is antithetical to the project of anti-colonial world-making that international lawyers would articulate a ready-made utopic blueprint, not least because pushing past the injustices of our contemporary order demands different politics and indeed fundamentally different ways of relating to our planet. Vasuki Nesia proposes that world-making demands for reparations, including in the Register of Legal Claims, can serve to refuse and interrupt colonial racial injustice. For Nesia, a politics of refusal of the status quo of international law and the colonial world systems it reproduces serves the critical function of making alternative worlds seeable and knowable. Insofar as mobilizations such as the 2020 transnational racial justice uprisings or the 2001 Durban Declaration and Program of Action retell the story of the relationship among race, colonialism, and reparations, we might see them as enacting critical politics of refusal and interruption. They might also helpfully reorient international lawyers' attention and energy away from reifying the status quo and towards scholarship and praxis that can disrupt colonial injustice. And so, the question that is the title of my lecture: for whom is international law? There are many different answers to this question. It's for the powerful, it's for the weak, it's for no one, it's for everyone. However one answers this question, international law is a site of global contestation. It is a site that imperial hegemons have occupied in order to dominate, but it's also a site that those who have most powerfully contested this domination have repeatedly occupied. As international lawyers, we work in the service of all of these actors, imperial hegemons and anti-imperial resistors and everybody in between. It's crucial that we interrogate our service and that we have the courage to insist upon a global system capable of sustaining egalitarian interconnection across time and space. Thank you very much for your attention.
Good evening, everyone. Thank you for inviting me to be a discussant for Professor Akiyomi's keynote. It's a real pleasure to be here with all of you. It's a bit overwhelming in a time when we are literally fighting for the basic principles of rule of law and basic principles of human rights and justice. And in democratic institutions that all of you showed up tonight to hear this distinguished speaker and scholar. It's really hard to follow brilliant scholars and lawyers like Tendai, but I will do my best. To her credit and to make it easier on me, when we met 2 weeks ago at Princeton, she told me, you don't have to comment on my remarks, just say what you want to say. While I shared my thoughts on what I would say today, I was also thinking, how would I do if I would do that? How would you react if I deviated a bit from the discussion format? Well, we shall see. It is indeed very hard to distance ourselves from the reality outside, from President Trump's executive orders and his administration's vicious assault on basic precepts of humanity and decency. While Trump might be seen as an anomaly, and in his failure to represent the American values of democracy, fairness, and justice that are so often touted these days, the United States' domestic and foreign policies are rife with examples of US exceptionalism and blatant disregard to the rules of international law and human dignity, both for people who live here and for those who are impacted by American wars or imperial wars, interventions, and exporting terrible instances of subjugation and oppression. And as you've heard from Professor Akiyomi, there's a number of examples historically, whether it's the appeal to the world and the way that actually our State Department and the Truman administration responded to W. Du Bois and how to deal with the Negro problem at the time, or how long it took our nation to ratify the Genocide Convention, and why was that the case? Only in 1988 that we ratified it, and yet it hasn't been really successfully made a difference, at least in the most serious and most egregious situations of violations of the laws of war or the laws of international law, particularly in the prevention of genocide, as we've seen in the recent federal court case that was brought by the Center for Constitutional Rights. It is also more recently in the Durban Conference, meaning in the last 20 years or so, how the United States has continued to reject the Durban Declaration and the plan of action to fight racism all over the world. During these dark times, when not only international law, especially IHL and international humanitarian law, and international human rights law are being ignored at best and shredded at worst, even more, domestic laws are blatantly disrespected and ultimately forgone, including bedrock principles such as the rule of law and separation of powers, with the independence of the judiciary being challenged at every instance, we come to collectively ask, what's the point of practicing international law and defending the rule of law? As I was preparing my reflections on Tendai's keynote, I thought maybe we should perhaps also thinking about using other methods to challenge the rise of fascism and authoritarianism. Perhaps even as lawyers and legal scholars, we employ other tools that might more effectively convey our message and spur collective action. So I decided to borrow from Professor Derek Bell's method of telling fictional stories to make my points and reflections, or at least borrow his fictional story. In his bestseller book, which I had to find in my old version, in my old copy, in his bestseller book, Faces at the Bottom of the Well, The Preeminence of Racism, Professor Bell uses fiction to illuminate truths about race and racism in the United States. I think those fictional stories are more topical than ever, especially his story about Harvard University's struggle with the lack of a diversity and abysmal record of low numbers of Black and other non-white minority tenured faculty and staff. And of course, in the context of the Trump administration trying to pressure academic institutions such as Harvard and others to and extort them in order to take control and reshape American academia. But what I want to share with you today is chapter 9, titled The Space Traders, because it remarkably captured the reality that we live in today. And I would like to just briefly tell that story if you have not read the book or that chapter. And it's interesting because it talks about space traders. So they are trading, and there's all these trade wars that now we are dealing with. But basically the story that Professor Bell tried to use is that the space traders are coming with a huge amount of number of ships and other cargo ships, and in order to, with a promise or an offer to the United States and to the leaders of the United States, if you let us take all your Black people, the millions, the 20 million or so Black people, and that's happened in the fictional story in January 2000, right? If you let us take all the Black people in America, we will give you in return the minerals, the rare minerals, earth minerals that you need, the gold, other resources that you need, and you'll be able to be a prosper. Would you agree to that offer? And then the story goes into what happens given that offer, both within the debates that is sparked by this offer. What are the forces that try to push back against it? Whether it's really worth entertaining such an outrageous offer, right? And what's important is that he highlights these different groups of people who are really pushing back against this against very dangerous offer and would never outlandish, and even anyone who could comprehend such a thing. And yet you will see that in the story there's a group, for example, of the Anna Frank Committee of Jewish resistors, activists who are coming together in secret in order to foil this plan. And others who are planning, including a story of a lawyer who is trying to be the token or trying to be making the case for the leaders, for the American leadership, why it would be a good idea. And yet, at the end of this, what we see is that essentially the amendment to the Constitution, which is, by the way, litigated, and there's also some interesting details there about how the case was dismissed, for why this space traders offer is not something that could be litigated before US courts. All of the things that we are hearing right now is actually in that story, which are really unbelievable when I had to read it again, preparing for this. At the end, the amendment passes 70 to 30%, 70 favoring 30%. And of course that, even though it was felt that it could be defeated, and there was a sense that no, that could actually happen, and it happens. So I wanted to even though it's a very grim reality, I wanted to share that because I'm going to come back to the space traders. But what I wanted to say and share with you some more hopeful things that happened in the meantime, in the last 4 or 5 years. In particular, I wanted to highlight important developments since 2020 that would help us address the significant deficit in making progress in the long run, especially with regard to remedying historical injustices and making international human rights more impactful and relevant, especially in light of the deeply grim reality we currently face, and lifting up those who are at the bottom of the humanities well, borrowing from Derek Bell's book title. First, for the first time, global human rights mechanisms are not just addressing individual and national scale present violations of human rights. They are beginning to investigate and highlight, quote, the root causes of human rights atrocities or human rights violations. We've seen that in the EMLR, in the expert mechanisms on law enforcement and equality and law enforcement, equality and racial justice in law enforcement that was created after the uprising of 2020. And as a result of the advocacy of not just the 600 organizations, but the families of victims of police violence that we had supported for their demand to establish an accountability mechanism. While that was not focused only on the United States and has global mandate, and we have a member, former member, Professor Juan Mendez, who served on the EMLR and appreciate his service, we have seen that it has a very powerful mandate to look at the root causes and what it does to looking at issues such as reparations and linking between present-day violations and historical injustices, particularly in the context of colonialism and transatlantic slave trade. The second example is coming from the Palestine and Israel Commission of Inquiry that was created in 2021. Up to that point, most of the Commission of Inquiries that were established were temporary and had a mandate that was open to criticism because it was only focusing on Israeli violations of international humanitarian law and human rights law. The commission that was created in 2021 was for the first time had open-ended. It was not had a time limit on its mandate, but it also had a root causes, looking at the root causes of human rights violation, international humanitarian law and human rights law, as well as looking at all violations of international humanitarian law and human rights law that are happening not just in the occupied Palestinian territories, which was really the focus of most of the Commission of Inquiry, but on the entire historic Palestine, that is Israel today as well. That is really significant. The other example is coming from the Commission of Inquiry on Ukraine that was also established right after the invasion of Russia into Ukraine and had also root causes mandate. The other significant development that I'd like to highlight is the demand for reparations, as you've mentioned, and I don't want to repeat things that I've said, but prior to the Secretary General call for reparations, the High Commissioner for Human Rights, in response to the 2020 uprising in the United States and around the world, made the call for reparations in her statement to the Human Rights Council. That was the first time that the High Commissioner addressed the question of reparations head-on in this context. We've seen also the report that was mentioned earlier, the landmark report from 2021 to the Council, which was based on what we call the George Floyd resolution that was enacted in 2020, asked the High Commissioner to prepare a report on racial justice, and then following that, the Council created EMLR, the expert mechanism on racial justice and equality in law enforcement that had a really effective, much stronger mandate than anything that we've seen from before. I would also mention the third concluding observation, particularly for the United States. In August of 2022, for the first time, CERD took up the issue of reparations. And it was based on what was happening in the United States. The movement for reparations has been going on in the United States for decades. It was only after 2020 that it got a little more mainstream and had become even a subject of the presidential campaigns. And yet, the CERD has not taken the issue of reparations until to the 2022 US review. And now, the CERD committee, under the leadership of Professor Gay McDougall, is working on a general recommendation on reparations. The UN Working Group on Experts of People of African Descent, which was created following the Durban Conference, has centered the issue of reparations in its work, including in 2 country visits to the United States where it discussed the imperative of instituting reparations in order to address equality and historical injustices. And two more examples where I think it's really important to follow that are incredibly important development is the UN Permanent Forum on People of African Descent. That was, again, centered reparations as part of the 4 or 5 goals, as well as the decade for people of African descent, which was extended by 10 more years, because the first 10 years, most countries ignored it, and then we had COVID, and now we have another chance to center the call for reparations as essential part of the forum's work, including working on a UN declaration on the rights of people of African descent. And finally, as just an example, recent example, last year at this conference, since last year's conference, is the ICJ advisory opinion on the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem. We have seen the ICJ advisory opinion also addressing the issue of reparations in the context of its legal opinion with regard to the prolonged occupation and its status as an unlawful act under international humanitarian law and human rights law. The last important development that I would like to mention is development in the context of centering directly impacted communities in the process of documenting, investigating, and debating solutions and accountability measures for rights violations affecting their past, present, and future. EMLR is, again, a great example where we had, in the context of the George Floyd resolution, in making sure that the work of this expert mechanism is closely consulted with directly impacted families and people, individuals, and communities, which has been the case since its establishment in 2022. The same thing for the Commission of Inquiries that had the root causes and centering directly impacted communities. For the first time, you see on the podium of the Human Rights Council representatives from these communities addressing the council, not from the back of the room where they would have like 2 minutes to rush to state or re-traumatize themselves, but rather have a respectful position, engaging with the world and with the council on this issue. The ICC investigations understanding that victims of atrocities have is another hopeful example that I think is really important to emulate and to see developing the status that has standing in engaging, in making interventions and carrying the rights of those impacted and victims. Now, let me return to, I think, connect to what we heard from Professor Kiyomi about the role of lawyers, and back to Professors Derek Bell. In the space traders, we've seen that the focus is rightly so in the eyes of Professor Derek Bell and also other people in the United States that have investigated, researched, and written about race and the law. We've seen that the black people are the ones to sacrifice in order to make this country better or great again, if you wish. And this time, I want to warn that what is happening is not just Derek Bell saying that there are the black people who are going to be offered to be sacrificed, but there are other communities as well. Palestinian rights activists that are being snatched and abducted from college campuses and universities with no due process whatsoever and being whisked all over to remote abusive immigration detention facilities, to migrants who are really now at the forefront also of the Trump administration's threats to strip them of their humanity and deport them with no protections whatsoever. Non-refoulement protections doesn't exist. No due process, expedited. It is just that. We see the transgender community. We see other vulnerable communities that will be impacted. And so what's the role of our role as lawyers? What are we going to do? Many of you work in civil society sectors and different organizations are doing important work. Many of you are working in law firms that are being attacked. And so are we going to be, or maybe some of you are still in the government and doing your best. So this is the time for us as lawyers to define who we are and what's our role in the face of the history of racial injustice, but the history of violating human rights en masse. Are we going to be part of being complicit, or complicity is what will make us survive, or resistance? Is it capitulation or pushing back? Should we have an ethical rule, just like the physicians and the medical practice? Do no harm. Should we think about those role models, the people lawyers who really did the right thing and paid heavy price for doing that? Those who were a visionary and really had so much to offer and do for us. I suggest that we all think about what's the little thing that we can do? What are those small things that we can do in order to prevent the atrocities that will be committed, not only here, but also its impact overseas, its impact on the international law and its principles, its impact on international institutions that we, as imperfect as they are, we have no alternative but to protect them and defend them from attacks. We also the role is not only to disrupt or delay. We have a role to stand by the most impacted, the most vulnerable communities, to help shape the vision of the role of law and how to use it for the best impact on everyone. Thank you.
Thank you both, Professor Chume and Mr. Dakwar. I think it's best left to just stay with the last words that we heard about, for all of us to think about what we're going to do and what we can do and what we should do. With that, I will again thank you for your powerful, insightful comments. And I think we all have a lot to think about. So with that, I will close the Grotius lecture for this year. Thank you.